Hi, my name is Frank Nunes from the law offices of Frank M. Nunes in Fresno, California. My practice emphasis is in helping people injured by others' carelessness get the compensation they deserve, and I've been doing so for over 22 years. The two questions that I get asked the most are, who can attend my deposition, and why is my case taking so long to settle? A deposition is a question and answer session where a witness is questioned usually by the adverse side's attorney. The witness's answers are given under oath, which is the same oath that would be given if one were testifying before court and or jury. Well, you're not going to believe who can sit in on a deposition in California, and this may sound like a bad joke, but I once went to a deposition where the witness's mother, the witness's father, the witness's priest, and the witness's mechanic all showed up for the deposition, and only the driver was giving testimony. How can this be? Well, generally in California, anybody who wants to attend a deposition can, since depositions are done in place of questioning every witness in court. So by this logic, in California, where most court proceedings are open to the public, in other words, anybody who cares to watch, depositions likewise would be open to the public as well. In addition, the witness can bring somebody who can provide moral support to the witness. They're not obligated to do so, but if it makes the witness feel better to have their parent or their spouse or their priest or in one case their mechanic present at the deposition, they're definitely allowed to do so. So anybody, unless there's a court order limiting who can attend the deposition, can attend a deposition in California. Now, when there is a court order, typically it's issued to exclude other witnesses who may be testifying in the same case, and for that reason, the court will preclude them from listening to another witness's testimony before their deposition is concluded. They want to hear each witness's version of the facts untainted by listening to the other witness's version of the facts so they can get the most truthful answers to the question. The second question involves settlement of cases and why they take so long to be complete. In the personal injury realm, it's very important to gather all the harms and losses resulting from a careless person's actions or inactions, so those can be placed before the careless person's insurance company or the responsible party who's going to compensate the injured party for these harms and losses. They typically want to do a single settlement, and they don't want to do it piece by piece. So oftentimes you have to wait until the person has reached maximum medical improvement, or if you have a prognosis that they were more likely than not going to have a surgery or a medical procedure, and this is the estimated cost for the future care. When you gather all of these items together and put them before the insurance company, then there's a clear picture of what the case value will be. Many times it takes several months for people to complete treatment. In some cases, I've had clients who've had multiple surgeries and then multiple recovery times after each surgery and training and therapy to get them back to where they were. So sometimes it takes quite a bit of time, and we are actually forced to file a lawsuit in those situations. But as a general rule, most cases resolve in about 2 to 3 years at the outset. California law prohibits a lawsuit being filed from lasting more than 5 years on the docket, so there is an incentive to get these cases resolved as quickly as possible. Well, thanks for listening, and if you have any further questions or you are in need of personal civil injury litigation advice, visit www.nuneslaw.com or call 559-436-0850. Thank you.